petitioner in this case, my lord. Petitioner before this court is not arraigned as an accused at the time of FIR. Now I'm made an
Better cooperate with
accused
the
number
investigation,
3.
my lordship.
So what?
Allegation, my lord. At the first instance, my lord, let us see the true facts of the case. I produced this by way of a memo dated 9/9/20. I am the accused number 3 now. Initially, my lord, the accused number 2, claiming to be an assistant manager at Accenture, introduces me to accused number 1, who says he is the regional manager. Now, page 7, my lord, of this memo is the offer letter that came to me. By this offer letter, I had to deposit a sum of 42,000 rupees. I transferred this said sum to showcase that I also have produced my bank statement. I am a principal at a school, my lord. Now, after I was offered this job, I also bring about my other friends and relatives who together invest, or rather give this refundable deposit a sum of rupees 75 lakhs. Now, once we get to know that there was no job that was coming our way, first instance, I present a complaint. That complaint is in page number 1. They say it is civil in nature, lower petition ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ LTP ಮಾಡ್ತಾರೆ. This is dated 28/9/2023. Then, my lord, this impugned complaint comes to be filed in January 2024. Then they say you would have to take bail. I take bail. Then after I take bail, my lord, only this is a very important document, page 42. Let us for a moment read this endorsement. ಈ ಅರ್ಜಿಯ ವಿಚಾರದಲ್ಲಿ ಬೆಂಗಳೂರು ಜಯನಗರ ಸಿದ್ದಾಪುರ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಮೊಕದ್ದಮೆ ಕ್ರೈಮ್ 2012-24 ರೀತಿಯ ಪ್ರಕರಣ ಅರ್ಜಿ ಎದುರುದಾರರ ವಿರುದ್ಧ ದಾಖಲಾಗಿದ್ದು, ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿಗಳಾದ ಕೊಟ್ರೇಶ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2, ಪ್ರೀತಮ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ದಸ್ತಗಿರಿ ಮಾಡಿ ನ್ಯಾಯಾಂಗ ಬಂಧನಕ್ಕೆ ಕಳಿಸಿರ್ತಾರೆ ಹಾಗೂ ಹಾಲಿ ಪ್ರಕರಣ ತನಿಖೆಯಲ್ಲಿ ಇರುತ್ತದೆ ಎಂದು ಪೊಲೀಸರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ನೀವು ನೀಡಿದ ಅರ್ಜಿಯನ್ನು ಮುಕ್ತಾಯ ಮಾಡಿ. My complaint meets with the fate of closure on the very ground that this crime is being investigated.
We'll direct that also to be opened.
My lord, but I am a victim in this case, my lord. There is no allegation of entrustment, especially with in the impugned complaint, my lord. Let us for a moment.
I'm not hearing this for the first time.
Please, my lord, your lordship was pleased to call the records.
I have seen the records.
Yes, my lord. In page number 28, my lord, there is no overt act against me. It is not that I induced. It is not that he had paid money to me. If that were the case, I would completely understand. But that is not the case at all on hand, my lord. The only allegation which comes in where he says is, ಏನ್ ದುಡ್ಡಿದ್ಯೋ ನಾನು ಕೊಟ್ರೇಶಿ ಮತ್ತು ಮಧುಮತಿ accused 2 and now me petitioner ಕೊಟ್ಬಿಡಿರ್ತೀನಿ. But I produced my bank statement to show only debit, my lord. There's nothing that's come to me from the accused. I am truly a victim in this case, my lord. And now the police are using this as a weapon of harassment by issuing 41A notice, by threatening to cancel my bail, even though I am willing to cooperate. They are issuing only one notice. But my lord,
You want some more notices to be
oh
issued?
my lord, I'm saying that I'll cooperate as a complainant, my lord, because I am a victim in this matter. Even I have lost money in this case, my lord. That there is no entrustment. There is no allegation that I have pocketed this money. And it's definitely not the case that I impersonated to be somebody from Accenture. Those are not forthcoming in the complaint at all, my lord.
Anything else?
There is no prima facie case, my lord.
Not a case for interference act.
My lord, even if that were the case, his end even in the complaint, he requests nan ದುಡ್ಡನ್ನು ವಾಪಸ್ ಕೊಡ್ಸಿ ಅಂತ. Civil in nature, my lord. ನನ್ನ ದುಡ್ಡೇ ಇರೋದನ್ನ ಹೇಗೆ ಕೊಡ್ಲಿ? ನನ್ನ ದುಡ್ಡೇ accuse number 1 ನನಗೆ ಕೊಡ್ತಿಲ್ವಲ್ಲ.
It is not mere recovery of money. If that was the case, I would have stayed it. There is something more than that.
But my lord, as regards
Why did you all take money?
I did not take money.
No.
I have
Accused
given
1 and
money.
3 is all right.
Accused number 1 and 2, my lord.
Ah.
I have not. I have in fact given money. My bank statement is forthcoming of that. Page number 12 to 40, my lord. I have purchased my bank statement. It is not the case that I
You
have
cooperate
taken
with the
money.
investigation.
My lord, then let there at least be an order that they don't take any coercive
They will not
action
take
against
coercive action. You're already on bail.
me. But they've been
But
threatening to
If you
cancel
don't
the same
cooperate,
money.
they will cancel.
Three
My
times
lord, we have
she has
been-
not, 3 times she has not appeared.
No, my
But
lord.
if she-
Only
When,
once,
when do you appear before the investigating officer?
my lord, only once notice was issued. Immediately we responded.
When do you appear?
As per this, my lord,
Now when do you appear? Next week?
my lord, I would still press for the interim order.
No.
It is not a case, my lord, where I had any intent is being attributed to me.
We will
either.
see. First cooperate with the investigation. Yes. The learned counsel for the petitioner shall cooperate with the investigation. The petitioner is already out on bail. The investigating officer is said to be threatening the petitioner that the bail would get cancelled if the petitioner would not appear before the investigating officer. In the event there is non-cooperation on the part of the petitioner, it is always open to the state to take appropriate action in accordance with law. Accordance with law.
21st month.
The petitioner, the learned counsel for the petitioner undertakes to appear before the investigating officer on the 21st at 10:30 a.m. The investigating officer therefore shall not take coercive steps till the petitioner would appear on 21st before him. Yes, before the IO. Next, list on 26th. Appear before the investigating officer. Yes.
Lord, I represent the petitioner. I'm sorry, my lord.
ನೀವೆಲ್ಲ ಯಾರಿಗೆ
petition.
ಅದಕ್ಕೆ ಸೇರಿ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ. All of you are for petition.
My colleague is there, my lord. In fact, I'm sorry, I could not personally appear there. My lord, this is a matter of Pokso. The victim is said. Please, my lord. Yes, my lord. 17 years. Yes, my lord. Please, he is.
So what is the age on the date of the incident?
17 years, 11 months. At page 88, the victim's birth certificate is there. Page 99, the accused petitioner's age is there. He is 20 years.
Now you have a child?
No, my lord.
Aborted.
Abort. Why?
Minor.
No, she went there by 3rd month.
DNA report is matching.
DNA
report
matches. Then where is the certificate of marriage?
Marriage is
My lord, they are not married. What
Not
has been
married.
agreed between, they are not married. What is been agreed is that because the boy is 20 years old and she is 18 now.
All right. Okay, 2019 agalva.
21 is marriage.
Please.
Or 21, sorry.
Yes, my lord.
21, that is the reason. So the parents, both respective parents have agreed, and even the victim is willing to file the necessary affidavit.
ಈಗ bail ಕೊಟ್ಟು ಆಚೆ ಕರ್ಸಕ್ಕಾಗಲ್ಲ unless I settle it.
If I may submit, with a condition saying that I shall file an affidavit before the trial court, the petition may be allowed. In the sense, post while I am supposed to produce the order copy, post he is released, when he is set at free, he shall file affidavit, necessary affidavit. If not, before this court only.
No, I can't direct marriage also.
Your lordship may stay it and then.
I'll stay the proceedings. Stay other, you take advantage of that.
My lord, in fact, I have one IA has been filed. It shall be filed if the bail application can be considered. I'm just, the IA is there.
The petitioner is the accused, presently 20 years. The daughter of the second respondent is the victim.
So, first informant is the victim itself. Respondent number 2 herself has.
Stayed by Puttenalli police station.
R2, my lord.
Victim herself, is it?
Please, that is what.
The victim, aged 43 years ಅಂತ ಹಾಕಿದ್ದೀರಾ? Correction ಮಾಡ್ಬೇಕಾದ್ರೆ ಪೂರ್ತಿ ಮಾಡಲ್ಲ. Yes. The respondent is the victim. At the time of the incident, the petitioner was 19 years and the victim 17 years and 11 months. Out of a physical act, it transpires that the respondent becomes pregnant, goes for a checkup wherein it is noticed that she was carrying 3 months, and at the date of and as of the date of the incident, she was 17 years and 11 months. This lands the petitioner into prison. the learned counsel for the petitioner submits that the families of both the petitioner and the complainant have all agreed to get the two married. The learned additional SPP, taking this court through the documents, would submit that the DNA of the child, though it was aborted, matches with the, we depict that the petitioners are the biological parents of the said child. The petitioners have not yet reached the marriageable age in accordance with law. In the light of the aforesaid circumstance, owing to the hard realities of life, I deem it appropriate to stay further proceedings against the petitioner, a boy of 20 years old, till the next date of hearing. Place the matter on 16th October for the hearing.
My lord, if I may submit,
Huh?
let there be an observation that
1 minute,
this
sir.
would not.
Matarbedu. Wait.
I'm sorry.
Trial court can consider his bail application because if they stay, they will not.
No, it's stay ಮಾಡ್ತೀನಿ. Yes. In the light of the interim order granted, it is open to the petitioner to move the concerned court for grant of regular bail. And if moved, the concerned court shall bear in mind the observations made in the course of the order and consider the application seeking such bail in accordance with law.
Much obliged, my lord.
Oblige. Sorry.